Our talk this morning is critical path for dummies. That's not to suggest anybody here is a dummy, honestly. I'm Russell Bates. I'm a principal at HKA, and I'm just going to do the easy bit, the introductions. This is essentially about the critical path. And first of all, my colleague Harris is going to give you a talk on the analyst perspective. And then following that, we've got David Sortel, who's kindly come to us from 39 Essex Chambers. David's a barrister, and he's going to give you the view of the legal team. Just to introduce our speakers now, Harris is a chartered civil engineer and delay expert with extensive experience in civil engineering, building and construction projects, as well as forensic delay analysis. He's worked on major and iconic projects in North America, the UK, Europe, Africa, the Middle East and Asia. And this has covered projects such as hospitals, rail projects, power stations, refineries, oil tank farms, and residential developments. He's been appointed as a delay expert in both adjudication and litigation, and has been recognised by Who's Who Legal Construction Experts 2022. David specialises in substantial construction, infrastructure, PFI, and property disputes. He is regularly instructed in building safety disputes, domestic and international construction, energy and engineering disputes, in litigation, adjudication, and arbitration. This is especially where there are complex issues of law, causation, or expert evidence. Notably, he was a lead counsel for a core participant in the Grenfell Tower inquiry. He also researches and publishes academically on construction law. He's co-editor of the History of the Technology and Construction Court on its 150th anniversary. And he published SCL paper 229, which addressed causation in the English construction law, time for reinstatement. Without further ado, I'll pass you over now to Harris to start the discussion.
Okay, thank you, Russell. I would also like to thank you for being here. I think we have an exciting agenda for today's presentation. I would say that this presentation is like a soft intro to delay analysis. And to start off my part, I will provide an introduction to the concept of programs, including an overview of the different types of programs. Next, we will delve into the critical path, discussing how it is identified within a program and exploring various scenarios that can affect the critical path. Finally, we will address some common errors, some common deficiencies in the programs that can impact the critical path. I promise my Mediterranean accent won't be too hard to follow. And don't worry, I won't put you on the spot by asking you to pronounce my surname. I know that it can be challenging. So now let's dive into the exciting world of programs. So basics things. A program is a listing of a project milestones, deliverables, activities, usually with intended start and finish dates. It's a representation of the contractor's intention on how the works will be carried out. The construction program should comprehensively outline the scope of work, clearly define the sequence of activities, and ideally specify the required resources. Now, in most programming softwares, the as-built activities are typically identified using blue color, while as-planned activities are represented by green color, and critical activities are denoted by red color. The most common form of contracts include a clause in relation to the programs. So the JCT contracts require the contractor to provide the architect or the contract administrator with copies of the master program. The program is also integral to the administration of the NEC 4 contracts. This clause is indeed one of the longest in the whole contract, which provides a comprehensive list of what the program should include to be issued for acceptance. And the FIDIC contract, of course, requires the contractor to submit a well thought out program within 20 days from the commencement date. There are different types of programs. The tender program is the one included in the tender documents. Sometimes there is no tender program in the tender documents. The baseline schedule is one of the most important programs and represents the contractor's intention to carry out the works as per the contractual dates. Typically, is the standard that is used to measure the performance of the projects. And the updated programs or program revision, revised programs, monitor the progress of the works as they are, and they often issued monthly throughout the course of the works. Of course, there is the as-built programs that demonstrate how the works were performed. So far, so good. But let's talk about who is responsible for creating the program. Establishing a construction program is not a task for just one person. It requires effort from a team. Now, unfortunately, a common bad practice is when the planning and commercial teams are the main contributors to the program. However, the best practice is to involve the construction team and the procurement team to have significant input in the program development. In this way, this ensures that all relevant perspectives are considered, leading to a more effective and comprehensive construction program. Now, directions on various issues in relation to programming software, to construction programming, and not only, offers the Society of Construction Law Delay and Destruction Protocol. I'm sure you're all familiar with the SEL delay protocol. It was firstly issued in 2002, and the second edition was in 2017. Now, as per the SEL protocol, the contract program should comprise a critical path method, should be in electronic format. The software should identify the critical path. The software should use logic links, and the program should avoid false criticality and avoid constraint. Specifically on the baseline program, the program should comprise the entire works, produced as soon as possible at the start of the project by the contractor. Ideally should flow from the tender program, and the level of detail should be proportionate to the complexity and the scale of the project. So, for example, you should not have a huge program for a relatively small project, and you should not have a short program for a large and complicated project. Now, let's move ahead to the critical path. So, in the programming softwares, the critical activities or the activities on the critical path are demonstrated in red color. So if you have a huge program with thousands of activities, there are many programs with 20, 30,000 activities, it's very easy to quickly see which activities are identified as critical. There are different definitions. There are several definitions of the critical path. This is the SEL, Society of Construction Law definition. The critical path is the longest sequence of activities in a project plan, which must be completed on time for the project to complete on due date. So if you are at the start of the works, the critical path will be the longest sequence of activities that drives the completion, the project's completion. However, after a few months into the project, the critical path will not be anymore the longest sequence of activities from the start of the project until the completion of the project, will be the longest sequence of remaining works from that point in time. Now, from the above definition, we should keep that the critical activities must be completed on time. So in other words, if an activity on the critical path is delayed for a day, then the entire project will be delayed for a day unless mitigation measures are taken. So having the concept of the critical path in mind, let's go to an example. So here's the example of a project that involves the construction of two separate buildings, A and B. The works in both buildings are planned to start at the same time, but building B is planned to be completed earlier than building A. So having in mind the definition of the critical path, longest sequence of activities must be completed on time. We understand that the activities in building A are the critical ones, since they have the longest sequence of works and they are driving the end of the project. You will see here that the critical activities, building A activities, are in red color because we identified that these are the critical ones. Let's now focus only on the activities of building A. Let's assume that the works didn't start as planned. And due to design issues, there were delays at the start of the foundation. So this is, again, only building A activities. This is the as planned. And now we've got a delay in building A, which the delay is indicated by the red hatched bar. So if no mitigation measures are taken, then this delay at the start will result to a delay at the end of the project. Therefore, any delay on the critical activities potentially can cause delay at the completion of the project. So why the critical path is so important to the project? Understanding the critical path allows the contractor to prioritize which tasks require greater attention. Tasks that fall along the critical path have a direct impact on the project ability to be completed on time. By identifying these critical tasks, the contractor can focus on finding ways to reduce their duration, which may result in cost savings if successful. As far as the EOT claims is concerned, the Society of Construction Law Protocol mentions that the contractor potentially will be entitled to an EOT only for those events or causes of delay that impact the critical path. And David Schotter will explain to you more on this issue later. Now, we have mentioned about programs, about the critical path. We haven't mentioned how the critical path is identified. So the critical path is identified through the critical path method, CPM is called, which was first developed in the United States in the 40s and contributed to the success of the Manhattan Project. Each activity in the CPM method is represented like this. It's a box with different attributes. So initially, the contractor makes some reasonable assumptions about the durations of each activity. What we know initially is the durations of the activities. Then we link the activities with the appropriate relationships, and we have a few relationships that we can link the activities. And from this point onwards, using maths, we can calculate the various attributes of each activity. I won't waste your time explaining the maths behind the CPF method. Now, this is what the critical path method calculates for each activity. Is the early start and finish of an activity, which are the earliest dates that the activity can start and finish, the late start and finish of an activity, which are the latest dates that an activity can start and finish without affecting the project duration, and the float. I cannot emphasize enough about the importance of float concept in the program. The float can be calculated by subtracting the early finish from the late finish. And the activities with zero float in the program are the critical activities. But let's understand more what the float means in a program. So in our previous example with the two buildings, we all agreed that the critical path ran through building A, and we explained why. The reason why building B is not critical is because building B has float. Building B can delay 1.5 months without impacting the completion of the project. Now, on the following slides, we will see some examples of how this float can be consumed and how the critical path can switch from one activity to another. But before that, it is important to list some main characteristics of the critical path. The critical path is dynamic, is not static. The critical path possibly will change sequence throughout the project. The critical path identified in the baseline program possibly will not be the same as the actual critical path. The critical path could change from one program revision to another, adjusting to the new conditions of the project. And is sensitive. Can be affected by various events, including productivity, change requests, lack of information, natural disaster, and pandemic. Now, in the following slides, I prepared an example of a project where we can apply different scenarios and see how the critical path is affected. Hopefully you can see. Yeah, I think it's fine. And our project is the construction of a new hospital where the contractor is responsible for the overall construction of the interior and the exterior works. And the client is responsible for the design, procurement, and installation of the medical equipment. Now, the baseline program is demonstrated in this slide, where the activities under contractor scope are in dark green, and the activities under client scope are in light green. You've probably noticed that the landscaping works and the medical equipment works have a certain amount of load. So having in mind what we discussed earlier, you will agree that as per the baseline program, the critical path ran through the main hospital works. Now, let's now work on different scenarios. All right, that's the first scenario. This is the baseline program. It's exactly what we saw in the previous slide. Now, as per the baseline program, the works were planned to start in early January 2016. However, let's assume that due to late mobilization of the groundwork subcontractor, the foundation work started in early March 2016. So there was a 2-month delay. This event will affect the critical path. If no mitigation measures are taken, then this delay at the start will push the completion date over the planned completion date. So in that case, sorry about that. So in that case, the critical path will be extended. The whole duration of the project will be extended. Second scenario. Let's assume now that the works progressed as per the baseline program until the end of May 2017, which is this red dotted vertical line. So the activities are now demonstrated in blue because they are as-built activities. By May 2017, the actual critical path is expected to follow the baseline critical path because there was no delay whatsoever. Let's now assume that at the end of May 2017, the client instructed a variation order at the original scope of the landscaping works. Let's say the construction of a new water feature. As per the contractor, due to this variation order, the landscaping works were now projected to finish 3 months after the planned completion date of the project. Will this new event affect the critical path? At that point in time, the landscaping works will have the longest sequence of works. Therefore, on this occasion, the critical path will switch to the landscaping works. This new instruction resulted to the change of the critical path in the landscaping activities. And it's possible that the contractor is entitled to also to an EOT due to this event. Let's investigate now another scenario in the same example. As before, the works progressed as per the baseline program until May 2017. The contractor projected that due to this variation order, the landscaping works will entirely consume the float included in the baseline program, and the works will finish at the same time, and the landscape works will finish at the same time when the fit-out activities were planned to finish. So the contractor estimated that the project completion date will not be affected by this client event. So will this critical path be affected from this event? Will the critical path remain on the main hospital works or change to the landscaping works? Now, in this case, both the main hospital works and the landscaping works are driving the completion date. At this point in time, both the hospital works and the landscaping works are critical, since they both driving the project completion. Therefore, the critical path will run through both of them. We can say that these two sequences are concurrently critical in May 2017. Let's go now to the last scenario, but it's the most interesting one. Let's say that in April 2016, the client informed the contractor that they had difficulties in carrying out the design of medical equipment. And they estimated that they will probably need another 5 months to finalize the design. So the contractor updated his program to reflect this event. And similarly to the previous scenarios, due to this event, the critical path switched from the fit-out, from the contractor's works, to the client's medical equipment works. Moreover, let's say that the contractor requested an EOT and actually was awarded a 2-month EOT for this relevant event. However, what actually happened, and here you will see in blue color are the as-built activities, what actually happened. What actually happened in the project is, in general, the project was 2 months late, but actually the medical equipment managed to finish by the time of the planned completion by mitigating the medical equipment installation works. So actually the medical equipment did not delay the planned completion date. The fit-out works were delayed by 2 months, and it appears that at the end of the project, the fit-out works were driving the project's completion. So after the project's completion, the client sent the contractor an adjudication notice, and in their referral, the client requested that the previous awarded EOT should be canceled as wrongful, because the medical equipment, the delay at the design of medical equipment did not cause any delay to the project. As per the client, the critical path of the project ran entirely through the contractor's works that had actually the longest sequence of works. The contractor from their side supports that at the time the program and the EOT claim was issued, the critical path ran through the medical equipment path. Therefore, the EOT was rightful. So which critical path is the correct one? Is the clients or the contractors? Now, to be honest, both of them are correct. Because it's like comparing apples and oranges. So the client's critical path is retrospective, is assessed when the project is complete, when having acquired all the knowledge, with the benefit of hindsight. The contractor's critical path is prospective. So this critical path is based on assumptions on the activity's durations. Now, the purpose of this example is not to confuse you, but rather to demonstrate the complexity of the critical path concept. Let's carry on the next subject, which is the program deficiencies. In this section, I will quickly go through various issues, deficiencies, inadequacies that we often see in the program submitted to the client. Now, the contractor does not provide the native electronic format of the planning software used to prepare the program. So in many cases, specifically in bespoke contracts, the contractor is not obliged to provide the native electronic format of the program. Without the native program, it's not possible to see the links between the activities, the float of each activity, and check whether the program has been updated properly. A further very common issue is that a program narrative is not provided. A program narrative is a document that includes all the assumptions made from the contractor to provide all the assumptions to prepare how the contractor prepared the program. So this is a very, very useful document. And if there is any change between the program revision, the contractor should provide all these changes made into this program narrative. The program is not updated regularly. This is very common error, let's say. We often see the last 5-6 months of the project, the contractor does not issue any program. There are missing activities. Programs will not include resources. So we'll review some of them in detail. Now, one of the things that is very common in the baseline program is that the baseline programs have limited information. There are many missing activities. A baseline can start with 300 activities and that ends up in the program revisions with 1,000 activities. For example, it's very common in the programs, more often in smaller projects, that there is no breakdown of the fit out, for example. And this is causing misreporting problems because it's very difficult to properly measure the progress of the overall fit out activity. And if the baseline is not properly done, then also contractors' claims are difficult to be supported. If a baseline program is not detailed enough, it is difficult to prove that the specific variation order, for example, impacted the critical path. It's very difficult to prove cause and effect. Another issue that we often see is in programs where we've got different sections, and each section has separate liquidated damages. We often see that the contractor provides a program identifying one overall, the overall project critical path. Now, however, the good practice is, apart from the overall critical path, the contractor should provide separate critical paths for each section. In this way, the contractor can identify whether variation order impacted the critical path of this specific section. Now, in the last slides below, I will talk to you about how the critical path can be manipulated. And let's start with with the basics. 5 years ago, I was requested by a client to review a program, an EOT program submitted by the contractor. And the name of the program that the contractor submitted was the following. And this is real. And what I'm trying to show here is that, apart that this is funny, is that programs are very, very easily manipulated. And how programs can be manipulated. But first, what means manipulation of the program? So a very simple answer to this question is, since the critical path method identifies the critical path, manipulating the program means manipulating the critical path of the project. So the planner can use the tools provided by the programming software to change the critical path. So, for example, can appear as critical an activity that is not in reality. Now, some of the tools that the planners use to manipulate the programs are the introduction of constraints, changing the duration of the activities, changing calendars, changing the links between the activities. And I'm not going to explain in detail all the above because we're entering in very, very technical fields. Constraints. So a constraint is a restriction or limitation you set on the start or finish date of an activity. So for example, in the program, you can set that this activity will start on 20th of May. Now, the overuse of constraints do not leave the program to breathe, to react dynamically. And therefore, it is possible that the overuse of constraints mask the critical path of the project. And the SCL protocol suggests that the planner should make limited use of constraints. Another method to change the critical path is to change the duration of the activities. This can be done by changing either manually the duration of an activity or by changing the calendar of the activity. So in the program, for each activity, a calendar is assigned for each activity, a calendar is assigned. For example, the foundation works will be carried out 5 days per week, or the design works will be carried out 3 times per week. Changing the calendars of each activity will change the duration of the activity as well. And let's now see an example of how the critical path can be impacted by changing the durations of the activities. We're going back to the example we used earlier. The project is a construction of a new hospital. And on this slide, the baseline program is demonstrated. I only have the critical activity, the critical sequence of activities. Now, the start of the works delayed due to contractors' mobilization issues. Now, the contractor updated internally each program and projected that this event will eventually cause critical delay unless mitigation measures are taken. However, the contractor didn't want to show that this delay was impacting the critical path. He didn't want to issue this program to the client. In order to mask this delay, the planner decided to reduce the planned duration of the fit-out works, and he rescheduled the program. So what the contractor managed to do by reducing the fit-out duration was that the program didn't show any critical delay anymore. Therefore, masking the critical delays due to the late start of mobilization. Of course, I understand that in many occasions, the contractor will try to mitigate earlier delays. However, the changes in the programs should be clearly identified in the program narratives that accompany the program. So if the contractor made any change, this should be clear. And we've got two more slides to go. Another important reason that can impact the critical path is the logic of the program itself. So we mentioned earlier about the good and the bad practice. Some planners use the program as a claim tool. So I prepared an example to solve this. Let's assume that in the previous example, apart from the main works, a flagpole should also be installed on the hospital's balcony. However, for some client reasons, the flagpole procurement delayed, and it was projected that the flagpole will be quite late to reach site. Let's say that the client issued a very late variation order in relation to the flagpole installation. So the planner updated the program and actually changed the critical path, indicating that it will run through the flagpole. And due to this event, there will be a delay to the completion of the works. So I'm using this example to demonstrate how the program is often used for claiming purposes. We all know that the flagpole installation will never delay the practical completion of the works. And we should not forget that the logic of the program should be as reasonable and simple. We often see the critical path in power plants, for example, to go through the landscaping works. This doesn't make any sense. And demonstrate how easily the programs can be manipulated. So that's it from my part. Hope you enjoyed it. David, would you like? Great.
Absolutely.
Great.
Well, thank you very much, Harris. And I'm going to give the perspective from the legal team. So now we have received our expert report, and it shows deep sign of manipulation of critical path analysis, flagpoles bound, even though we know they're not going to be critical for our power station, no matter how many flagpoles there are going to be. But what is the legal implications of all this? How do we apply a legal analysis to this? And I would say at the outset, there are two important considerations. First is causation, and the second is contractual interpretation. Because ultimately, we have a critical path analysis because we want to show an entitlement under the contract, or conversely, to show that another party doesn't have an entitlement under the contract. So the starting point is causation. And I've taken a quote from Lord Hoffman, writing extrajudicially, that when it comes to causation, the law defines the conduct giving rise to liability, and it's also inevitably define the occurrences for which one will be treated as responsible. The law never says simply that one is liable, one is always liable for something. And this is a very important part of all construction law, because you need to establish what the implications are of what actually happened on the project. Because it could simply be the case that laying out the white lines in the car park had no implications whatsoever, no matter how late you procured the white paint. And that's a point that comes from the evidence, but it's also a question of legal analysis. And I've taken a quote from case Royal Brompton Hospital NHS Trust against Hammond number 7. Yes, this was a very troubled project and piece of litigation. But ultimately, again, as Harris described, it was a hospital project which ran into quite serious delay. And in this part of the case was a claim for professional negligence against the architect, who they'd said had negligently granted extensions of time. And the difficulty here, and as a point that the trial judge, Seymour QC, sitting as a judge of the TCC, picked up on, is it's very credible and very possible to identify relevant events under a contract. the more difficult part is then to show how those relevant events, this was indeed a JCT form, it was in fact a 1980 form for all you old school Stranger Things JCT partygoers, what actually it shows under the contract. And the relevant term was this, whether completion of the works is likely to be delayed thereby beyond the completion date. And you'll see similar words in different standard forms. And the example that the judge gave was where the work is already being delayed because perhaps the contractors had difficulty obtaining sufficient labor. And then while that's in play, an event takes place which is a relevant event. And had the contractor not been delayed, would have caused him to be delayed, which in fact, by reason of the existing delay, made no difference. So here we have a relevant event, but it simply had no effect on the completion date. And as you can see there, we have a mixed tripartite analysis of factual causation, looking to see what was on the critical path and actually causing delay to the project. We have a question of an analysis of legal causation. Was it legally causative of it, or was it simply the occasion for any delay? And then finally, we have the question of contractual interpretation. And quite often as construction lawyers, we like to elide all three of those elements. But when considering what we mean by critical path, it's important at the outset to keep in mind those two distinct elements, causation and contractual interpretation. So in causation in facts and law, first of all, you need to prove the event that you rely upon engages the contractual mechanism, such as an extension of time, as a matter of fact. And that's where we're going to come on to look at the critical path analysis. Does it, in fact, disrupt the critical path? Does it push the critical path along, or does it not? Secondly, it must be an effective cause of the loss and not just the occasion of the loss. And indeed, so often in construction projects, there are things that simply happen in the background, but are simply not considered to be legally causative, such as, for example, issues in the project team. I think the third point, one which we frequently overlook in construction projects, is whether there's a break in the chain of causation. So you might have a relevant event which is ongoing, but whose causative potency is entirely wiped out by another event which does not give rise to an entitlement under the contract. And these novus actus interferens should not be discounted when carrying out a form of delay analysis. And Harris has pointed to the Society of Construction Law Delay and Disruption Protocol. And indeed, this has been endorsed by the TCC on a number of occasions now in its second edition, but I don't think the wording has materially changed from the first edition. So we're looking at the longer sequence of activities through a project network from start to finish, and the sum of whose durations determines the overall project duration. Why is that important? Because of that contractual interpretation. The completion of the works is likely to be delayed thereby beyond the completion date. If it's not going to affect the completion date, then possibly it needs to be taken out of our claim or our defense of an entitlement. And another point which Howard's alluded to, particularly when it comes to sectional completion, there may be more than one critical path depending on the workflow logic. I mean, that is baked into the definition. Another point which isn't so obvious from that is that they can draw the analogy with a horse race or horse racing. At the start of a horse race, you have possibly 10, 15 horses all going off. And the critical path will be the length of time it will take for the first horse to actually finish the race. At that point, then you know who has won the race. But during the race, different horses will overtake each other. And on a very definite, crisp critical path analysis, the critical path is jumping from one horse to another as they're moving ahead. And at that point, stepping back, you could say that we are simply not applying the right analysis of the critical path in terms of legal, factual, and legal causation. Indeed, sometimes the near critical path activities can be just as important or more important. And Harris has already alluded to the fact But sometimes, heaven forbid, programmers like to protect the critical path by manipulating the duration or indeed the logic chains. And the final part of this is a delayed progress of any activity with critical path will, without acceleration or resequencing, and of course we know that acceleration or resequencing might themselves give rise to an entitlement under the contract without necessarily giving rise to a claim for an extension of time, cause the overall project duration to be extended and therefore referred to as a critical delay. I wanted to look into a good legal definition and analysis of the critical path, because indeed, as you've heard, it's a concept that arose in the United States and was prevalent in United States construction law for quite some time before it crossed over the Atlantic to England and Wales in the 1990s. And you will see some reference to it in 1990s law reports, but it's only really into the late 1990s, into the 2000s, we start to see it being adopted. And now you'll see in TCC decisions, it's simply being referred to and being discussed without there being any consideration being given to what actually it is, because it's now part of the landscape. And Judge Tolman QC in the 2007 case of Maryland Asia Pacific Construction actually gives a very useful definition and discussion of what the critical path is and draws on a number of the definitions that you've heard today. He referred to a British standard as saying the critical path can be defined as a sequence of activities through a project network from start to finish, the sum of whose durations determines the overall project duration. And the second point he made is this, which was quite a change. We could see this change happening in the 90s and the 2000s, is can you deduce the critical path inductively or impressionistically? Because so often you will see in witness statement evidence, this wasn't on the critical path or this wasn't delaying the project. And of course, in a more complicated project, you simply cannot identify the critical path just by sitting back and thinking about it. You need to carry out that logical analysis. And this is, we'll come on to looking at project records. This is part of a problem where the project records are incomplete or simply missing, because it's been incredibly difficult to reconstruct what was happening, what was on critical path, and what wasn't critical at any point of time during the contract. He made the point that there may be more than one critical path, but the last point is so important that I put it into italics. The critical path analysis is a tool or technique to assist in the management of construction projects and is not an end in itself. And I think so often as construction lawyers, we are keen to put forward the expert report and saying this speaks for itself, without taking that step back to saying, well, what does this actually show? Where do we then take the expert report and apply a legal analysis to it based on the terms of the contract? So going back under JCT, for example, to looking at the relevant events, and then looking causatively as to whether we can link those relevant events to delay in the project by using critical path as a tool, and then going on to show that we can establish an entitlement under the contract, be it for time or for money, and being aware that a different contractual interpretation may apply for an entitlement for time compared to an entitlement for money. So the headline point is the critical path is a tool, it's an evidential tool, but is not the end point of a legal analysis. And this is where our counsel now takes the heavily intricate and beautifully presented diagrams that Harris has put together, and then puts a very crude one together just to make a point. Here we have a diagram taken from Royal Brompton Hospital from an earlier part in the litigation. And we have a progress trundling along nicely when the project is hit by a labour shortage. So indeed, going back to Judge Seymour's comments, the labour shortage starts, and then subsequently, then there is a relevant event. And conveniently, for the purpose of this slide, they both finish at exactly the same second. Who would have thought it? And then we go on to see the progress continuing. And the point here is, in fact, that relevant event causatively did not impact on the completion date. So in terms of our entitlement under that form of contract, we cannot link the occasion of a relevant event to an entitlement under the contract. So the critical path is an evidential tool. And like any good talk about delay, you have to go back to Malmaison, which is one of the most important judgments to read when considering delay analysis, even though most of these were in fact concessions being made by counsel, and a lot of it was agreed. And if you read Malmaison afresh, you'll see it's all to do with the scope of the arbitrator's jurisdiction. Because the question was, when you carry out a delay claim, and what was the scope of the arbitrator's jurisdiction, could he then, or could she then, consider any potential defences, such as other events, which might be affecting critical path or not? And what was held there was that this is a question of fact in any given case as to whether a relevant event has caused or is likely to cause delay to the works beyond the completion date. So again, we are coming back to this point. It's a question of identifying relevant events, looking at the critical path, and then establishing its causative potency. Indeed, that is what ultimately any good delay analysis should tell us. Given the factual importance of this, then, and stepping back as the legal team, I can say, well, that's great, but where is the evidence for all of this? And I think this is one where the transactional construction lawyers and the dispute construction lawyers can probably shake hands and agree, because it's so important to keep records, increasing emphasis to keep records. And unfortunately, some projects we see, records are not kept, and trying to put together a critical path retrospectively, relying on nothing but site meeting minutes every month, where the contractor gives a thumbs up and says it's going okay, is so difficult. And then it makes it incredibly difficult then to analyze what is going on site and what entitlements arise for each of the parties, whether you're entitled to termination, if in fact you're arguing that such is the extent of the failure to make progress, that you are entitled to terminate the contract. And there's no mistake, and it's not simply a question of randomness. For the SCL Delay Interruption Protocol, says core principle 1, contracting parties should reach a clear agreement on a type of records to be kept and allocate the necessary resources to meet that agreement. And so often you will see buried in the contract preliminaries an obligation on the contractor to have the most whiz-bang model programming. It's kept up to date pretty much month by month or even week by week on the latest software, applying all their resources, and send it to the employer. And you ask for these records and it's like, no, that didn't happen. Did they ever ask for it? No, they never asked for it. So that's okay then. And then it's so difficult to actually then argue persuasively one way or the other as to whether the expert witness has got it right or not, because both sets of expert witnesses will feel uncomfortable to reach their conclusions, because when you ask for the basis of their analysis, you realize they're actually debating on very little material indeed. The next part is factual evidence, and I'm going to remind you of what Judge Tolman said. It can be deeply unreliable to ask a project team what was actually happening without then considering the project documentation at the time. Not simply the ongoing analysis as to we think it's in delay, but also what was being recorded at the time contemporaneously about what was in delay and what was causing it. And in my experience, the best ones, best claims are actually ones where it's quite well documented and notices, not simply formal notices, but there's dialogue being given, and you can point to warnings being made. And it's far easier then to construct a chronology and a narrative, because when you look at the law reports, that's exactly what the judge is going to have to do if they're deciding your case, or being asked an adjudicator to determine it, or an arbitrator to determine it. They are going to have to carry out that analysis. Finally, the expert evidence. But of course, the expert evidence is only as good as the material it's based on. And without proper evidence for it, as I've indicated before, it is unfortunately too easy then to poke holes in an analysis. Yes, you can go back to expert evidence and factual evidence as to the logic links. I've seen expert reports going on for 120 pages telling me how to make a lattice truss structure, but they make a point, because the liability and what action precedes another action can be very important indeed in a delay claim. If the logic link doesn't work, it simply doesn't work. And you might find, like the lattice structure, it simply doesn't hold together. So the expert witness in your delay claim might be beholden, might rely upon the other evidence, including the other expert evidence in your case. And also, I think it's also important to note this, knowing what's happening at point by point might also be important when it comes to a claim for money. And the best illustration of that is possibly Waterley and McKay, where it was noted that your claim for money might well depend on what the costs are being incurred at each point in time, and the need to try and link that to the claim. So it simply isn't good enough necessarily to say you can have an extension of time unless you're defending a claim or bringing a claim in respect of liquidated damages. You will also need to show how that part of the delay report and those delays are actually then causative. So ultimately, you end up with a structure of expert opinion and then judgment being applied. But ultimately, it's up to the legal team to bring it all together by reference to those legal principles, and then to present it clearly and credibly by reference to established principle. And that is why I consider, as the legal team, it's so important to work together as a team in bringing these claims and in defending these claims, and why indeed the critical path analysis and knowledge of it is so important in these kinds of disputes. Thank you very much.
If we'd just like any time for, if there are any questions for the panel. If so, I'll bring round this microphone so people can easily talk into it.
Hello. So on the issue of concurrent delay, which I know is always eye-rolling, is it your position that the critical path has to run through all the alleged concurrent delaying events, and therefore you need more than one critical path to run through both events? I mean, yeah, I'll stop there.
I assumed that concurrent delay was going to be the topic for another talk. Oh. I have to say, I thought that critical path for dummies, and then going on to the exciting topic of that. I think concurrent delay shows us in some ways both the power and the limitations of critical path analysis, because depending on the legal interpretation of concurrent delay, you are looking at a situation where you have a relevant event and another event which doesn't give rise to an entitlement, running with similar causative potency arising on some analyses, particularly some would say the overly restrictive SCL delay instruction protocol arising at a similar time. And if you were to look at it on a critical path analysis, it might well look as if they are two causes running in parallel. But the definition of concurrent delay doesn't refer back to a critical path analysis. What you're looking to see is at that time, and looking at when those two events started, you are looking at two events of similar causative potency running concurrently. So yes, it's a tool, but I think when it comes to concurrent delay, you need to in some ways keep part of critical path analysis at all, and then look at the factual situation as it's happening and the actual effect is actually taking place. I don't know how this was add to that.
Just a comment. Within SCL protocol, it's mentioned that concurrent delays are very rare. And from our experience, working through delay expert reports, this is what we see. In SCL protocol, it's mentioned that concurrent delay happens when you've got two events, one client's event where the client is liable, and one contractor's event where the contractor is liable at the same time, and their impact is felt at the same time as well. So from our experience, we found it very, very difficult. So to this event, even though there were some cases that we have two concurrent events. Normally, and I'm going back to what I explained before. If an event, if we've got a sequence of activities that is driving the critical path, and at some point in time we've got a contractor's delay event, then the delay, this will have as a result to extend the critical path. Now, to have a concurrent critical delay, we should have another client's activity at the same time with the contractor's client, which is pretty rare.
So just on your point, Harris, if the red line that you were showing wasn't running through an event, you wouldn't say that the event that doesn't have a red line on it isn't a concurrent cause of delay. I realize it's a difficult question. It was more a kind of a...
No, very good question, Jonathan. I think that we've got two events that are concurrent, but these two events do not affect the critical path. Both of them do not affect the critical path. So we have one event affecting the critical path, and the other event will not impact the critical path.
Thanks.
Anybody? I'll come round.
Thank you. Sorry, I should have sat a bit closer. So as I understand it, you've got the question from the outset of the project when you have the baseline program or the master program, as the JCT describes it. And you can look at that program and you can determine what the critical path is based upon that program, which is the sort of first scenario. And then you have the question at any given point during the project. You can then do a separate analysis as to what the critical path is at that moment. Exactly. So there's two different scenarios there. Exactly. And I noticed that there was reference at various points to projected delay or forecast, as the NEC contract would describe it, or retrospective delay analysis. And I think that there's two key different approaches there, as anyone who's been involved in delay claims will recognize. My question's about which one you think is correct. And I think it's worth bearing in mind, because I suspect part of the answer will be it depends what the contract says and which contract it is. But what I think is interesting is that the NEC contract clearly envisages forecast delay analysis because it uses those words. The JCT contracts don't use those words unless they're amended, but they do have a master program at the beginning. But then interestingly, if you look at that comment in Walter Lilly, there is a reference to what's critically delaying works as they went along, which suggests a forecast approach is appropriate. So there seems to be a bit of inconsistency there. And I wondered if you had any thoughts on whether it should be the first scenario, the second scenario, or it simply depends in the context of JCT and NEC.
I'm happy to take that first. And I think you've obliquely referred to a Northern Ireland case of healthy buildings, where you take an NEC contract, and as you say, it's worded prospectively, and it should be analysis on face of a contract, which should be analysed prospectively. And in that Northern Ireland case, the judge refused to limit himself to a simply prospective analysis, but considered they're entitled then to look at what had actually happened, because otherwise it'd be an abstract exercise. We have yet to see whether that analysis will be applied in England and Wales. And as we've seen with the Scottish case of City Inns, different parts of the, put it politely, the North Atlantic archipelago apply contractual provisions in different ways. Do I think that is correct? I think it's difficult to ask a judge to discount evidence which is plainly admissible unless there's a clear rule of law, such as in contractual interpretation, as to what the parties did after the contract. I think it is, when you're looking at on what Healthy Buildings was quite an unusual situation where the exercise was carried out several months after the claim. I mean, it's difficult to persuade a judge that they should discount all that. Having said that, and I note your reference to what Mr. Justice Aikens had said in the McKay case, you should look both forwards and backwards for sort of a Janus-faced approach to entitlement. I think that probably is the best way to approach it, because after all, we are looking not only what the contract administrator has in front of them, but ultimately as a court, tribunal, or adjudicator, we're looking to see what their ultimate entitlement will be, which is a very wishy-washy answer. But ultimately, I'd say you should look at the admissible material, and you should try and look and apply the contractual terms. But it's then difficult to discount evidence as before it could be before the decision maker.
Yeah, from my point of view, when the project is ongoing, somehow we should measure the impact of a variation order. For example, we should somehow measure how the program and the overall completion date will be impacted. So we only have the prospective method when the project is ongoing. Now, after the completion of the project, we've got several tools, like prospective or retrospective method of analysis. And actually, we've got 3 different types of critical paths. We have the retrospective critical path, as I showed you before. We've got the forecast critical path, and we've got how it is called in the SCL protocol, actual or contemporaneous critical path. Now, nowadays, in many cases, you'll see that the experts are trying to identify in their program, in their expert reports, the contemporaneous or actual critical path. This is not entirely retrospective, but it is an assessment of the critical path of what was critical during the project of the works, during the course of the works. So it's somehow a hybrid critical path.
As an observation, I think where we are, if you call it as an industry, as a niche, is I think the heyday of the prospective type analysis is long gone. Some of you may be familiar with a case called Skanska v. Egger, which I think was the high point of when prospective type approaches were in their heyday. Since then, and I think very much to respond to what the courts require, what we do tends to focus on being fact-based analysis. The contemporaneous approach that Harris has spoken about probably nowadays, it's based on an internal survey done in HKA, is the predominant approach that experts, delay analysts will adopt nowadays. The perspective, and I think you're quite right mentioning NEC, I've got an NEC dispute at the moment and something that I'm having to agonize with. So it's still there as something you have to contemplate. But I think in the main, when you come to talk to experts, we're looking either back wholly retrospectively or this contemporaneous approach whereby we track events as they develop through a project and at any particular time are thinking, well, what's happened now to bring us up to this point in time? And what is it we've still got left to do? And both of those factors contribute to our understanding of what is critical at that particular time. It probably confuses you a bit more, but
something on that. So on NEC contracts, I've worked on adjudications that even though NEC, even though the project was under NEC contract, the experts identified the retrospective, the contemporaneous critical path, not the prospects perspective. So in terms of delay analysis, they didn't use a time impact analysis, but they used an as planned versus built type of analysis.
Would anybody else have a question for the panel?
Thank you. I had a question on manipulation of the data and the programs that you talked about earlier. As counsel, we typically only have the benefit, typically only have the benefit of reviewing the PDF formats of these programs. And also we have a lot of contemporaneous evidence where people are filing lots of notices in order to corroborate what that manipulation would be. So my question is twofold. One is, how do you identify as counsel and advocate that such manipulation has taken place without potentially the benefit of the native files? But also, how do you, how is it not deemed as waiver when the manipulation happens in the middle of the program and the parties have operated with that program and haven't raised any issues? Could there be an element of a waiver of any problems?
I'm happy to take on the waiver point. This is a critical path analysis is an evidential tool. And when you're using a critical path analysis part of a delay claim or claim for an entitlement, you're simply looking at the evidence. And as a second stage then of analysis as to whether or not there's been a waiver, such as, for example, whether there's been reliance and whether there's been perhaps detriment, I think it would be quite difficult to show that everyone knew what was going on projects, but we all agreed that that the critical path analysis was a bit of a fudge, and we all decided to get on with it anyway. And I think I'd be surprised to see that. I think it comes more to the point where one party is simply unaware, or basically simply unaware, or doesn't know there's been some protection of a critical path by, for example, manipulation of the duration of different activities. How do you argue that? How do you argue there's been a manipulation of it, which may be inadvertent, it may be entirely innocent? I think you have to simply argue from the evidence. And to me, I'd be going back to the factual and liability evidence to show what are in fact the logic links, what were in fact the durations. You may need to go beyond people simply clocking in and clocking out, but may need to go look, for example, at photographic evidence, at webcam evidence I've seen showing actually what are people doing on site. You may need to look at the project administrator's records, looking at materials, and then you can show that actually, even though something is said to have a certain duration, it doesn't in fact take that long, or a liability expert can say there's simply not criticality between the activities, or it's simply that sort of duration simply doesn't take place. But I completely agree, it's very difficult to show it.
Yeah, from my side, now if the programs are in PDF format, it's really difficult, to examine and to assess how good the program is. However, there are some ways to do that. For example, if a program mentions that shows that the start of foundation was on 20th of October, and you find a photograph showing that it was in November, that's clearly a discrepancy. There are other ways, but they are quite technical things. And of course, if it's an arbitration ongoing, then of course you can ask to disclose this, the native programs.
Would anybody else like to ask a question?
Good morning. Related to project records specifically, what we've talked about here today is really about the tools and techniques for evidencing your critical path and program management. Do you see any significant difference between that evidential tool set versus what the project teams have to use on a day-to-day basis for the management of the project itself?
Yeah. So from my point of view, no, not at all. What I need from the team is everything that they're using in their daily works, how they monitor the works daily, what resources they're having on site. Nothing more than that. We have seen many times that, and this is our main issue, that we are not provided with the documents that we need, as David said, to carry out our analysis. And this costs money to the client afterwards, because we are spending so much time just compiling, just trying to compile the factual matrix of all this data set. So from my point of view, no, I don't need anything else than what is recorded in their daily operation. Of course, the documents should be as detailed as possible. So we should have good records, good progress records. We should have drawings, photographs. We should have monthly progress reports, daily diaries, so as to help us doing this job properly. For example, we didn't spoke about disruption here today, but a disruption claim is really difficult to be substantiated if you don't have daily records, for example. And in many cases, even for very large contractors, you won't find this kind of documents.
I mean, I'm going to concur with that. Often what you see is the information is aggregated together for purpose of presenting a claim, but it's only when we haven't got the information to aggregate together that we have to look to more imaginative sources of evidence, which maybe weren't available to the project team. And it's very easy to take an eagle-eye view and take a holistic view of all the materials at one point, but it's only when that documentation, as I said, simply isn't there that we have to consider more novel sources of evidence, such as the weight of materials and weigh bridges going into site, or clocking in records, or things like that. You are better off having contemporaneous documentary record that should be available to the project team at that point, even if, because they're doing the job, they wouldn't necessarily be looking at it at that time.
Anyone else?
Hello. I was just wondering whether, and if so, to what extent in practice you're seeing that sort of tension that you've discussed between a prospective and retrospective analysis is leading to the sort of reopening of claims. I mean, I've certainly seen both on the employer and the contractor side where, you know, an engineer or an architect on behalf of an employer has at the time awarded an EOT or declined to award one. Once, of course, you get to the end of the project, you know, then you can sort of, with the benefit of retrospect and a retrospective analysis, take a different view. Is that something that you're sort of seeing in practice, and something that's widespread?
Yes, definitely. So when the project is ongoing, the contractor, to demonstrate the impact of variation order, let's say, it will make a prospective analysis. That's the only way. So what the contractor often do is what often is using are two types of delay analysis methods, time impact analysis or time slice analysis, to show the impact of the delay event to the project's completion date. Of course, when the project is finished, and with the benefit of hindsight of what happened during the project, the independent experts will see the big picture of the project and will eventually decide whether this delay is exactly what I was saying before about the medical equipment, whether this delay actually affected the project or not.
I completely agree with that. I mean, I see cases where a project has come to an end early due to termination, and we're then considering, well, why was that EOT granted? What was the basis of that grant? And then we're kind of having to then redo an analysis or do a completely new analysis to establish entitlements under the contract for the purpose of a final assessment of what each party is entitled to. So yes, very much so.
Thank you. Anyone else? I'll take that as a no. Okay. So to just wrap up, if I can thank everybody for coming today, and thank you for all the questions. And just finally to say thank you to our panel for their contribution today. So nice to see you all. Hope to see you again soon.